Hey, what's up guys? Today we're going to talk about applicable law, also known as governing law. Now, applicable law or governing law refers to the body of law that governs a contract or a dispute between parties. Now, generally, parties are usually free to choose the governing law of a contract. For example, if two parties in Singapore decide that they want to buy and sell shares in a Singapore company, they can actually decide to use Hong Kong law as the governing law of the contract, even though the shares itself are the shares of a Singapore company. If the parties do not make a choice of the law that governs the contract, or if they make an invalid choice, then the applicable law will be determined by the court, and there will be tests and considerations applied by the court in deciding the applicable law for the contract or for the dispute. In the case of contracts, when there is an express term in the contract setting out the governing law that will govern any disputes under the contract, that law that is stated in the contract will be the applicable law when deciding on any disputes. If, however, parties to the contract did not specify or choose the governing law to govern the contract, and there is litigation or lawsuits arising from the contract, then the court may infer a choice from the contract and the surrounding circumstances at the time of the making of the contract. If the implied intention of the parties cannot be determined from the substance or the circumstances surrounding the contract, then the applicable law is the law of the country or system of law with the closest and most real connection with the transaction or the parties. In international transactions where each party may not agree to have the contract governed by the other party's laws, the contracting parties may, as a compromise, choose a neutral third party to govern the contract. So, for example, if one of the contracting parties is from Singapore, another one is from Malaysia, and the Singapore party does not feel comfortable to use Malaysian law, they may choose to use English law or Hong Kong law to govern the contract. When there is no express term in the contract which sets out the agreed governing or applicable law, then the court will take into account certain factors in deciding the country or system of law. When deciding the country or the system of law that has the closest and most real connection to the dispute, in the absence of an applicable or governing law clause in the contract, the court will take into account several factors which will include the language of the contract, the terminology used in the contract, the form of the documents involved in the contract, the currency used in the contract, for example, British pounds, Malaysian ringgit, Aussie dollars, and the places of residence or place of business of both of the parties to the contract. Let's examine the local High Court case of Las Vegas Hilton Corporation and Sunny. Now, the Las Vegas Hilton had a liaison office in Singapore whose function was to identify rich people to gamble in Las Vegas. One of the representatives of the casino discussed with the defendant Koo the VIP benefits of gambling at the Las Vegas Hilton. Koo then arrived at the Las Vegas Hilton and signed a $1 million credit facility. And as you can expect, Koo lost heavily at the casino and overdrew the credit facility. Koo then made several part payments for the amount that he borrowed from the casino, but eventually he stopped paying. So the casino had to sue him in Singapore. Koo argued that the contract that granted him credit facilities, essentially a loan, was made in Singapore between him and Lee, the representative on behalf of the plaintiff casino, Las Vegas Hilton. So Koo also argued that because the contract was made in Singapore, it was void, because in Singapore, gambling at a casino is illegal. So the issues that the court had to decide were the place where the contract to grant credit facilities were made. Where was this contract made? In Singapore or in Las Vegas? The court also had to decide the proper law of the contract, whether it's governed by Singapore law or Las Vegas law. Finally, the court had to decide whether the contract was enforceable in Singapore. The court eventually decided that the contract was made in Las Vegas. The court held that the proper law of the contract was the law of Nevada, even if the contract had been concluded in Singapore. The court said that in the absence of any choice of law expressed by the parties, the transaction had the closest and most real connection with Nevada, because the loans were given in Las Vegas and the loans were made in US dollars. Secondly, the gambling was to be done at the plaintiff's casino in Las Vegas. Number 3, the plaintiff was not carrying on any business but only had a representative office in Singapore, and none of the parties were Singaporean. The only connection with Singapore was that the discussions relating to the grant of the facility were held at the liaison office in Singapore. Other than that, everything else happened in Las Vegas. Therefore, the court held that the applicable law to this contract for the grant of credit facilities took place in Nevada and was to be governed under Nevada law. So thanks for watching this video on applicable law.